Hi everyone. I would like to address in this video the connection between wills and family law, which I think most people will be surprised to find out that they are very connected, and your marital status can have a great impact on the validity of your will. So I'm going to start with what I think from my experience are the main points to consider and to understand regarding your family law situation and leaving a will. Again, a will is something that is left behind by a testator in the case that they pass away and they want to ensure that they leave everything to their beneficiaries and everything is taken care of. So a will only provides for your assets after the date that you are deceased. So that's important to understand. It's different than anything done during a lifetime. So I'm not addressing that at this time. Okay, so the first thing you should know, if you have children, you have the option to provide for a guardian, to appoint a guardian for your children in the will. The Children's Law Reform Act allows the person entitled to custody. So, for example, if you are separated or the other parent is not in the picture, there's a test to determine who is the person entitled to custody. Regardless, the person entitled to custody, according to the Children's Law Reform Act, is allowed to appoint in the will a guardian for the children. Now, having said that, sometimes the solution is not to appoint a guardian in the will because that guardianship usually expires after 90 days. So you might want to consider different strategies with a family law lawyer who has experience in wills and estates as well to determine what you should do to ensure that your children are well taken care of by the appropriate person. And you have to understand that we have the Children's Day Society in Canada, and they deal with what is in the best interest of the children and making sure that they are protected. So if you provide for a guardian that is not appropriate, or if there's another parent involved, things might get very complicated. So it is very important for you to understand the connection between family law, wills, children's law societies. It's important that you at least be aware of this so that you can make the best plan for your children. So I'm going to move away from this. It's a very complicated issue, and I am happy to answer any questions should you have any. The second piece that I want to deal with respect to family law and wills is what happens to your will if your marital status changes. Most people do not know that if they have a will and they get married, the will is automatically voided. This is a very important piece to this. So you should understand this. If you are in a long-term relationship, and let's say you're in a 10-year relationship, and you made a will and you provided for your spouse in there, and then you get married to the same spouse, you might run into issues. So unless the will is made in contemplation of marriage, which has to be done in a very detailed manner, obviously with good legal advice, then the will automatically be voided. So it is very important to understand that piece. Therefore, when you get married, you should understand what happens with your will. Now, on the other side, if you get a divorce, it is also very important to understand what happens. Does your will become automatically null and voided after the divorce? The simple answer to that is no. However, any provisions with respect to your spouse or ex-spouse in that case are null. So if you leave certain gifts to your spouse and you get a divorce, now those gifts do not go to the spouse anymore. And you might find yourself in a situation of intestacy, or at least partial intestacy, meaning that at least part of your property will be treated in accordance with the automatic laws that we have and not in accordance with what otherwise would be your wishes. So it is important to understand that piece as well. Now, the last thing I want to deal with, there's marriage, there's divorce. What happens to your spouse? What options does your spouse have in all of this? There's a very, very important time limit for the spouse of a deceased person. They can elect within 6 months of the deceased date of death whether they want to go under the laws of wills and estates, so what wills and estates would provide them with, or under what family law would provide them with. And in the latter case, it would be deemed as if the deceased spouse was not deceased and there was an actual separation in that case. So it is basically the same as being separated, and the spouse that is still alive would have the same rights that they would otherwise have if the other spouse was alive under Section 5 of the Family Law Act. So just to summarize that, the spouse has the option to either go under wills and estates or under what they would have been provided by if the parties had separated. So if you don't leave anything for your spouse in your will, then they can actually claim what they would have been entitled to if there was a separation. And if there was a divorce, then they would actually just be able to claim what they would have gotten under the separation, because in that case, there would have been a separation already. So that's very important to understand. And again, the strategy for getting to where you want to get and making sure that your property and your children are taken care of in the manner that you want is very complicated, and it might be that you need to have a strategy involving both family law components and a testamentary disposition, so by way of will. Therefore, for now, you should just understand if you have children, if there's a marriage or divorce, it is very important to obtain legal advice, or at least for you to be alarmed and to understand that some things may not be the way that you want them to be. And then there's other issues as well. If you have dependents and you do not provide for them in the will, there's a lot more complex issues as well. And again, the strategy really depends upon having a conversation and legal advice with a lawyer, as well as what your final goal is. I hope this was very useful for you. And if you have any questions, please let me know. I would be happy to address any concerns.